Well, thank you very much, and good morning, dear colleagues. First of all, I would like to echo the congratulations of Mr. Sandris and the representative of Science Academy to the WIPO winner award. And now let's get down to our topic. First of all, today, as you all know, we are celebrating the World IP Day, which is entitled for this year, Powering Change, Women and Innovation and Creativity. 2018 campaign celebrates the brilliance, ingenuity, curiosity and courage of women who are driving change in our world, who are expanding frontiers of knowledge and culture. So I see many, many women in this hall. I congratulate all of you. Well, now to the industrial designs. The term of industrial designs broadly refers to the creation of form and function of the objects of everyday use. But we all understand it, but despite of this fact, main international treaties such as Paris Convention, TRIPS Agreement or Hague Agreement does not contain any generally recognized legal definition of the term of the industrial designs, but we all understand what is it. Here are some samples of industrial designs which I took from our international register. Many economies currently earn most of their living through high-value creative industry, and without protection, investment, and development, their creative industries could falter in the face of developing international cooperation. We all understand why should we protect our intellectual property rights, especially what concerns the designs, because you know that designs, industrial designs, are surrounding us everywhere. We are sitting on objects of industrial designs. We are sitting at the industrial design object. Even iPhones you are keeping in your pockets also constitute the industrial design. Well, during my presentation, I will try to cover the basic topics, basic features and advantages, legal framework, going back, geographical coverage, some statistics, latest developments, and upcoming features. And I included into my presentation some specific issues introduced recently when 4 countries acceded to the Hague system, namely the United States of America, Japan, Korea, and the Russian Federation, because those countries, they made certain declarations and introduced certain requirements which should be met if you decide to designate those countries in your applications. Well, the main purpose of the Hague system is to facilitate intellectual property protection for industrial designs by investors in every country which is a party to the agreement through a single standard application filed directly with the International Bureau or indirectly through the appropriate contracting party's office. The agreement hereby simplifies the application process and reduces the cost for investors of industrial designs seeking to obtain and preserve their rights on a worldwide basis. Actually, there are three ways to obtain protection nowadays in the world. The first one, as we call it, the Paris route, when the applicant must file the application before the national offices, and if the applicant wishes to obtain protection in many jurisdictions, you understand that he or she must contact different national IP offices. In each country, the applicant must have patent attorney or agent. In each country, the application must be filed in national language. In each country, the applicant must have a certain amount of national currency to pay the fees. And as a result, the applicant will receive many, many documents of registration. The second way it is not shown here, but this is regional way. It looks like the Hague route, but with a limited number of countries. Today we have the representative of European IP office, and he will tell you how it works. And the most efficient and the most cost-saving and time-saving way is the Hague route, when the applicant who managed to file the ideal international design application is dealing with only one office. This is International Bureau of the World Intellectual Property Organization. Well, the Hague system is a closed system. Not everyone can use it. Here are the 4 entitlements which are necessary to be indicated in the international application. First, nationality. Second, domicile. Then, real and effective industrial commercial establishment. And the 4th one, introduced by the 1999 Geneva Act, the most recent and sophisticated act to which Latvia is a contracting party. Well, main features: simplicity, cost-effectiveness, efficiency, and flexibility. Well, actually, simplicity means that the applicant will meet the requirement to follow the minimum of formalities. One form, one deposit valid in all designated countries, one set of fees, and one currency to pay the fees. Cost effectiveness. You know that a couple of years ago I calculated the cost effectiveness taking certain number of countries, certain number of designs, certain number of reproductions, and choose 5 countries, including European Union, and calculated how much it will cost if I go to each IP office and if I use the Hague system. And saving was, if I use the Hague system, saving was approximately 65%. This is very huge amount of money, even for big companies such as Procter & Gamble and Gillette. But we should remember that the Hague system is a procedural arrangement. Such issues as conditions for protection, the refusal procedure to be applied when deciding whether a design may be protected, the rights which result from the protection are governed exclusively by the national laws of the governmental, or of the contracting parties, sorry. Well, what are the requirements to the international application? It should be filed into one of 3 official languages: English, French, or Spanish. It may be filed, as I said, directly to the International Bureau or indirectly to the national office if it's so allowed. In both modes are possible, e-filing and on paper. But as you know, maybe as you know, that paper filing on paper is much, much more costly, because when you file your application on paper, each reproduction will be charged with quite an amount of money, 150 Swiss franc per page. Well, the international application may comprise several different designs, up to maximum of 100, under the condition that all of them belong to the same class of the Locarno classification. And of course, the last requirement, the set of fees should be paid when filing the international application. The role of the International Bureau when we are considering the international application filed before the International Bureau and when we receive indirect international design application. We are carrying out formal examination. If the decision is positive, we are recording it in the international register, send the certificate of international registration to the holder, publish it in our bulletin, the official source of information, and this publication de facto is the notification to the designated offices to start their internal procedures, if any. I mean to carry out the substantial examination and inform us, notify us about their decision to grant protection or to refuse. Concerning refusal, we are receiving a lot of questions concerning refusals. Refusals may be issued by the contracting parties, which are designated in the international registration, but only on the grounds of substantive examination. On formal grounds, the designated officers cannot issue decision of refusal. This is first. Second, the refusal is limited to the within the territory of the country which office issued the refusal. So that means that refusal issued by one country, one designated country, does not affect the international registration in general. Duration of protection. The initial term of protection is 5 years, and under the Geneva Act of 1999, it could be renewed twice by 5-year period. But if the national legislation of a contracting party designated in the international registration, so the holder may renew the international registration till the maximum term of protection allowed by the national legislation of that contracting party. Well, just to compare, for you just to compare the advantages of the Hague system and national filing procedures. As you see, that if you are looking for protection in many jurisdictions, so in this case, you have many of everything, many offices of filing, many languages to fill in the application, many currencies to pay fees. And if you look at the Hague route, so everything in single number. One office for filing, one language, one currency, and so on and so forth. And the main reason to use the Hague system is that when you are filing international design registration, you don't need any representation before the International Bureau, and you don't need any patent attorneys in the designated contracting parties. This is very important because, as you may know, that in some countries, such as the United States, the services of patent attorneys and patent agents are very high. So when you use the Hague system, you don't have to hire the patent attorneys, even if you designate the United States or any other countries. Legal framework. The Hague Agreement concerning the International Deposit of Industrial Designs was prepared, as you may know, at The Hague. That's why we call it Hague, Netherlands, on November 6, 1925, and entered into force in 1928. That's why generally we are calling the system Hague system and Hague agreement. But the system is being operated on the basis of two separate acts. This is Hague Act of 1960, and the most recent, as I already mentioned, the most recent and most sophisticated Geneva Act of 1999. Sorry. As other international registration systems, we have common regulation, administrative instructions, and an integral part of the legal system of the Hague Agreement is national laws and regulations. Now, you know that recently many governments have changed their attitude to the Hague system. That's why we are watching, we are observing the activity of certain big economies to join the Hague system, and the system, as you see, is expanding drastically recently. Recent accessions. The most recent accessions, it was Russian Federation, and on March 13, 2018, the United Kingdom deposited the act of ratification, and starting from June 13, 2018, United Kingdom can be designated in the international application in individual capacity, because now you know that you can designate European Union, which includes all 28 member states, and of course the United Kingdom will be among this number of members. But starting from June 13, 2018, you may designate United Kingdom per se. As you may see that among recent accessions, we can see Korea, Republic of Korea, Japan, United States, Russia, of course, very big economies, very big territories, covering which you can obtain the protection for your designs. We are in a very intensive consultations with China, with Israel, with Canada, Mexico. We are expecting that Mexico, Canada will join the Hague system by the end of this year. China is expected to join the Hague system next year, early next year, but let's keep fingers crossed that it will happen, because I know that business all over the world is waiting for especially Chinese accession, because this is a real big economy, very strong, and of course the significance of such economy being inside the Hague system is very important. Recent developments. We are constantly working on our online services, especially we are trying to make more and more user-friendly our e-filing interface. Then recently we developed very important and very interesting instrument. That was our initiative, but of course, according to the requests from the users, we developed the guidance on reproductions, because sometimes the holders of the international registration started to receive refusals on the ground of insufficient disclosure of the industrial designs. That's why we decided to compile all the requirements concerning reproductions in one document, and we call it Guidance on Reproductions. And we developed this instrument in close cooperation with those offices who are with most demanding, you know, regarding the reproductions. Then we are still developing the new Hague Express database and the global design database. I will show you the interface if you didn't visit these instruments. This is very easy and very interesting instruments for search of international design registrations, as well as search through the some national databases. As I mentioned already, we are improving our e-filing interface. In particular, we introduced so-called e-loop in our e-filing, because before that function, when the irregularity letter sent to the applicant to introduce some corrections into the international applications, the applicant was hesitating. Okay, I'm ready to respond, but to which address shall I send this my response? And now we introduced such function as e-loop, and through the e-filing portfolio manager, the applicant may respond to this irregularity letter, which goes directly to the examiners of the International Bureau. And of course, on the last paragraph, developments in the legal framework. As you know that on an annual basis, the experts from all the contracting parties met in Geneva to attend the working group on legal development of the Hague system. Guidance. As I told you, you may open it on our web page. Practically it was already translated in all 6 UN languages. You can read it through, and I call up four of you to use it. At least look it through, especially at the last page where we place the table with certain special requirements from different countries. Here are just examples of some international designs which are past the substantive examinations, as well as, of course, the examination within the International Bureau. Now, the Hague Express and the global design database. As you see, the interface is practically the same. You will have a look at the search by tool. You may find the registration by design, just the name of design. As I made it here, you see I introduced watch, and the system showed me all the registrations regarding watches. By names, by numbers, if you know the numbers, by dates of registration, and by country. Also, we have a filter. It's very easy to use, but you will receive all the information concerning these registrations. If you click on each line, or the line you need, you will receive all the history of this registration, all the changes it introduced, if any. Everything is placed here. But please take into account that this is not official source of information. The only official source is the Bulletin of International Design. But anyway, it's very good for making preliminary research. This is how our e-filing interface looks like. It's very easy to use. Just establish your account on our web page, and please file the application, just pushing the tabs on your left and fill in the boxes which appeared on the screen. Very easy. It will take you, if your reproductions are ready, it will take you just 15-20 minutes, and you can file the application. The mode of payment we introduced here now, the opportunity for applicants to pay by credit cards, because we were receiving a lot of requests to introduce it. We had it regarding the renewals, but not for the filing applications. But now we introduce this opportunity also for filing. It is very comfortable and suitable for the users. Well, concerning legal framework, I didn't mention when I was speaking about the legal framework of the Hague system, I didn't mention the London Act of 1939. Previously we mentioned it because it was in force, but since October 2016, by the decision of the WIPO member states, this act was terminated. Now we again introduce the new function on our web page. We eliminated practically all the addresses, and we introduce only one opportunity to contact with the International Bureau, especially with the Hague registry. Just contact Hague. It is very useful again for the users of the Hague system, because you don't need to search for what kind of addresses should I address my questions and so on and so forth. Now only one single point of contact for users, and moreover that all the history of your communications with the International Bureau will be kept on your email. And we are finalizing, also very useful instrument, we are finalizing the Hague member profile database, because you know that recently we are starting, especially after certain recent accessions, we started to receive a lot of questions concerning the national requirements of certain countries, especially again United States, Japan and Korea and Russia, what kind of requirements you should meet to avoid possible refusals. Now we are developing this instrument with compilation of all the data possible and with certain search tools. Some statistics. 2017, 5,041 international registration were inscribed, containing 19,241 designs. We must admit that we observed 3.66% decrease as compared with 2016. But if you remember, I mentioned already that each international application may comprise up to 100 industrial designs. So due to that, we watched 9.3% increase in number of designs included in the international registrations. So it's very difficult to say what is good, what is bad in this respect. Well, the five most popular classes of international registrations. Class 14, recording, communication, or information retrieval equipment. Class 12, means of transport or hosting. Furnishing, clocks and watches, and lighting apparatus. Well, here I prepared the statistics concerning Latvia. I took the directory by the address of the holder. So in 2015, there was one international application originating from Latvia. In 2016, 3, and in 2017, 1. Subsequent, respectively containing 2, 3, and 1 industrial designs. Concerning the international registrations, practically the numbers are the same. What concerns the designations in the international registrations regarding Latvia, in 2015, there were 22 designations, in 16, 32, and in 17, 45. As you see, the intensity of designating your country is growing. Now, let's get down to the specific issues concerning the 4 countries which I already mentioned. First of all, United States of America. The most recent grounds for refusal in all those countries is the requirement of unity of design. So the United States have made declaration concerning Article 13.1 of the Geneva Act, under which only one independent and distinct design can be filed under a single application. This is the requirement of the US law, and they cannot change it. And actually they shouldn't, because there is an opportunity to make such a declaration. What does it mean? I made these pictures for you to understand. First of all, single design, it's fine. If it's good for the USPTO, they will issue a statement of grant of protection. Second, if some designs are included, as you see, the single inventive concept, if the experts of the USPTO consider this application, multiple application, as a single inventive concept, you will receive protection in the United States. But if you include in the international registration designs such as shown here, multiple designs including sets of variants. So mostly possible that you will receive the refusal from USPTO. It is very strict requirement for US, but everything will depend on the USPTO examiners. Second, it relates only to the US originated designs, but they made this declaration concerning the security clearance. The problem is, or not the problem, but the point is that in case of indirect application of international design application, the national office should transfer this application within 1 month, not to affect the application date. This declaration allows the United States to extend this period up to 6 months, and they made it. And I must say that all the American designers, they know very well this requirement, and they are filing international design applications just before the USPTO. We are not receiving direct applications from the US. Second, claim. This is mandatory and should be attached to international application. The claim should be provided, must be provided in specific wording. It is indicated here. The ornamental design for product, you indicate your product, as shown and described. This is again very important and mandatory requirement from the US. If you miss this phrase, so you will get the refusal from USPTO. Actually, you will receive from us first the irregularity letter, because we are carrying out not only formal examination, but we also, as our operations services said, we are carrying out formal plus examination. If we could advise to the applicant something not to get the refusal, we do that. Well, oath of or declaration of the creator, also mandatory and should be attached to the international application. So declaration, it's standard, as you see, standard WIPO form, DM1, this is a form of international application in English, French, and Spanish, contains such an oath. Electronic interface also contains this document, and you can download it from the USPTO website. Sometimes it is not possible for the applicant to get the signature of the creator under several reasons. So the United States legislation allows to attach the substitute statement when the applicant himself fill it in, sign it, and attach it to the international application. They will accept it. Individual designation fee. They will, since the USPTO is an examining office, they have the right to replace standard designation fee with the individual designation fee, and moreover, this individual designation fee should be paid in two parts. The first part should be paid when filing the international application, and the second, when the USPTO notifies you about the notice of allowance, in which they indicate the deadline for paying the second part of the fees. Moreover, the applicants may have the opportunity, are entitled to reduce the individual designation fees for when designating the United States. First, default, as you may see, the first part and the second part. Small entities and micro entities. As you see, very significant reduction. To get such a reduction, the applicant must indicate in DM/1 form in box 18, then fill in Annex 4, which is attached to the DM/1 form, and moreover, to fill in the certificates of the status, economic status of your company. So actually, we haven't received any clarifications concerning criteria from the USPTO, but as far as we know, small entities, meaning entities where not more than 500 employees are working. For micro, this is individual entrepreneurs, individual designers, and maybe some more. But anyway, as USPTO assured us, they are not checking all these papers. It's a matter of trust, as they say so. Actually, and we don't have any complaints from the business who are pretending to this reduction of individual designation fee. Specific issues to Japan and Republic of Korea. The legal systems of these two countries pretty similar. That's why I united them in a couple of slides. First of all, this is unity of design requirement. As regarding Republic of Korea, there is no such a requirement. So if you file the multiple design application designating Korea, so they will consider it and they will notify us the statement of protection as per se. Oops, sorry. For Japan, they have the same requirement as the United States, but for the international registration, they made the exemption, and when they receive multiple design registration from the International Bureau, they will ex officio, JPO ex officio will divide it into at the national level and grant and notify us the statement of protection. So that means that when designating Japan in a multiple design application, it means that you will receive protection in Japan. Now, concerning exception of lack of novelty, this is also mandatory because you know that sometimes applicants there disclosing their design somewhere in some journals and some exhibitions, maybe on internet, and only after that they will file the application for registration of this design. And if such if this happens, so you have the right to ask for a special regime in those two countries only, for exception of lack of novelty. For that, you will use box 15 of DM/1 form, and for Republic of Korea only, Annex 2, which is attached to the DM/1 form as well. Now, the Russian Federation. Well, unity of design requirement. Under the Russian law, and they made such a declaration, there are actually three requirements. One design per application, one set of products in application, and each item of these included in this set could be included in the same application as additional design. And another is one design and its variants, which are variants of the design claimed shall be visually differ from it and from each other by minor distinctions and or by combination of colors. So they made also this is the second country which made declaration concerning the security clearance, same as regarding the United States. Only USA and Russia made such declarations. Well, reproductions. For Japan is requiring 6 views minimum, meaning left view, top view, back view, front view, bottom view, right view. The Republic of Korea, US, and Russian Federation, actually they are not requiring so many reproductions, but the main point is that you should disclose the nature of your design. If it's enough to include 2, 3 reproductions, and you consider that the nature is disclosed, so that would be enough. But for Japan, 6 views, otherwise you will receive the refusal from JPO. Well, concerning the description, the presence of shading and dotted lines, as you know that this is a problem for many countries, especially now we are negotiating this subject with Chinese IP office because they do not consider dotted lines like we do. But anyway, for Japan, it is required to indicate what does it mean, dotted lines or shading. For Republic of Korea, they clearly understand that this is a disclaimer, as for Russia and USA as well. Just some examples of shading. As you see, in blue, this is shading, so the protection is not required. For gray parts, this is actually the subject of for which the protection is sought. Same with dotted lines, just the silhouette of the design and the heel. This is the essence of the design. Legends concerning the reproductions. Never put the legends on the reproduction itself, because otherwise you will receive the irregularity from the International Bureau. There is a special box for the legends where you can include all the legends you are considered important to clarify your reproductions. Here, box number 10 of DM/1. And here, as you may see, this is the contact Hague. As I told you, the only one possibility to get in touch with us, and I can assure you that after receiving your requests, we actually have a couple of days to respond. Otherwise, the system will punish us all. So thank you, and I'm ready to respond to your questions if I missed something in my presentation.